Good afternoon. It's Mark Wallace. Welcome to the Saturday afternoon legal hour with Judge Leonard Murray, who will be joining us momentarily. Before we get into our legal hour questions, today we're going to be talking about the Judicial Board inquiry, answering questions about that. So there are some questions about that people have sent in prior related to the Illinois State Judicial Board. So we're going to be talking and answer those questions. And also we'll be taking your legal questions, and the judge will answer your legal questions related to legal matters. Now, quickly understand that the judge cannot, and will not give legal advice. He will answer legal questions as it relates to legal situations that may arise. Also coming up on Monday night at 7 o'clock, Monday night, 7 o'clock program on intellectualradio.com, Instagram, YouTube, and on X, formerly known as Twitter. I am going to be talking and giving you the statistics and the data, nothing but the raw facts of the differences between the American presidents, of the Democratic presidents and Republican presidents. There's been 14 presidents over the last 87 years that, or Democratic presidents, and 7 Republican presidents. And we're going to be talking about how the economy is held and has fared under the Democratic administrations and Republican administrations. Nothing but the details. We've done a deep dive in that, and we're going to be talking about that Monday night. So make sure that you tune in for that on Monday night, and it's going to be a great program. So you want to definitely tune in to that conversation. All right. All right. We're going to get started. Judge Murray has just joined us, and joining me at this point, at this moment, every week, he is with me on for the legal hour. Judge Murray, welcome to the program. How you doing?
Good afternoon, Mark. How are you doing?
I'm doing just great.
Good.
I want to talk about some obvious issues. Now, you know what's going on with these court cases with the former president, and he is about to go to trial on his first criminal case in New York with the district attorney there, Alvin Bragg. And of course, the judge in that case has had to issue a gag order because Donald Trump has, in his rhetoric, has targeted the judge's daughter. And so the judge has had to put a gag order in place. But there are a lot of questions that people are asking as to how is it that a criminal defendant such as Donald Trump can continue to attack judges, district attorneys, or anybody who is moving to, or attorney generals for that matter, as to holding him accountable, that he could get away with such acts. Can you expound on that, coming from a judge's perspective, as to why he is giving so much latitude to do what he is doing and to behave the way he's behaving?
Well, it's not just your audience here, Mark. I have a very good friend who says to me, if he were Donald Trump, he would have been locked up a long time ago for the things that Donald Trump is doing pre-trial. And I think, given the atmosphere that we're in relative to leading up to the election, and some of the vantage points that some people are putting forth relative to why this is happening, why it's being allowed. I think the judge has been cautious not to do anything that might either create a political situation with respect to the trial and or give uh, Trump an even bigger platform to talk about how he's been treated differently than others. I don't know that that's a plausible argument because I think the judges have been very tolerant of his conduct, maybe more than I might, given the same situation and others that I know. But I think they don't want to give him an issue to go forward with relative to the political campaign, presidential political campaign. Ordinarily, it is not unusual for a judge to put a gag order on parties in litigation, um, primarily so as not to taint the jury pool one way or the other. Uh, and secondly, also so that um, there's no intimidation that is spread around those who might be involved. For example, it could well be that someone who might be a member of the venire, and that's the pool from which the jury is ultimately selected, might be intimidated to even sit on the jury because they may be fearful of what may be said against them relative to their judicial service. So I think the judge is being cautious here in terms of how they're giving Trump a lot of rope here. But I think that's the reason for it, that uh, and I'm not sure if it's male or female judge, but just because they want to be very cautious relative um, uh, any any public perception of how he's been treated. He's already, as you know, uh, claiming that he's been treated differently than others. Um, I don't think there's a good basis for that claim, but that's his claim. Um, and I don't think the judge wants to add any fuel to that fire. So he's been very very cautious in terms of not giving him any more ammunition to raise that question. Um, and the other thing, he is a past president, so there is uh, some degree of consideration given for that. And his um, security team, as you know, past presidents have security for life, and how all that works out in terms of litigation, civil or criminal, is very, very sensitive and touchy. So I think all of that plays into how he's being approached relative to what he's doing here. But clearly, it's not appropriate for him to comment on family members of the judge himself, the judge's staff, or anybody else who's part of this judicial process as it relates to him. But he has a history of that. As you know, he criticized the judge from Indiana a number of years ago uh, uh, on a case leading up to, I think, the presidential election of 2016. Um, so he has a history of that. And apparently, uh, he has never been um, sanctioned in a fashion that he feels intimidated against resuming and continuing that conduct.
Well, I think that the judge, certainly in the New York case, and the judge in the January 6th case, Judge Chutkin, who is the uh, black female judge in Washington, D.C., I think that they have certainly, those are the judges that have come under attack. And then, of course, Judge Engeron in the civil case in New York. So these are the three judges that have come under attack from him. But oddly enough, none of the 63 judges that they filed objection cases to the election, to the 2020 election, did he ever 63 judges ruled on 63 different filings against him, and many of those judges were um, Trump appointed judges, but he never attacked any of those judges. There are many people like yourself, in the legal field, out of the legal field, who have said, journalists, that this behavior is way beyond, this is way over the top, even for a former judge or a former president to be allowed to behave in this this way. And certainly, uh, we understand the judges taking, a real acute focus as to not to prejudice the case in any way in terms of his defense, um, or to um, try to prejudice or impact the campaign. However, he's doing all that he can to impact the campaign and all that he can to taint um, a jury or a potential jury for his case. He's doing all of that, and he knows exactly what he's doing. So all of his behavior is calculated behavior.
Now,
And
there is now a retired judge who I have a great amount of respect for, Bill Maddox, who sat in the Cook County Circuit Court for a number of years, was the presiding judge of the Law Division. And he once said something that struck me very strongly, and that is he had never sanctioned a lawyer. And I was somewhat surprised because given sometimes the conduct that lawyers engage in, sometimes it's just they're being human and they react inappropriately in certain situations. But what I took by that is the fact that you can do something doesn't mean that you should.
mhm,
So I have never sanctioned a lawyer either. And there are situations where it may have been appropriate, but I think just because you can do something, uh, maybe you shouldn't. And I'll tell you, I had a eviction case once a number of years ago where a tenant had reached an agreement with the landlord whereby they were going to forgive about $20,000 in rent. And it was a woman, not that it makes any difference here, but she had agreed to move out by a certain date. So the case was up on the date uh, for which she had agreed to term of possession. So as it happens, the case gets called, and she had not removed all the items of property that she had in the unit um, to restore possession to the landlord. And the thing that remained was a single couch. And I wondered whether or not $20,000 uh, was worth risking leaving a single couch for. And I can't imagine that the couch was more than a couple $1,000s. It must, plus it's used. It was a used couch. It wasn't a new couch. But one of the things she said to me is that when I explained to her, I said, "Well, you're really not making uh, wise choices here because these folks are walking away from a significant amount of money. I thought $20,000 in unpaid rent, uh, and you believe maintaining possession to remove a single couch is worth that risk." And she said to me, "Well, I can see you're angry because of a prior case that was up that morning." And I had to stop her. I said, "Look, miss, uh, if you all control me, then I shouldn't be sitting here. And you don't control me. So I think you just need to think about what's going on here and make a decision as to what you think is in your best interest. You've already reached the agreement. The agreement is enforceable. It was documented in the last order entered in the case. So the agreement is going to be enforced. You just have to make a decision for yourself today whether or not you believe a single item of furniture, which is what you claim remains, is worth $20,000. judgment against yourself. And I passed it, and they came back, passed the matter, and they came back, and she agreed to have this couch out by, I think, 6 p.m. that day. But restraint is important from the bench. Uh, there are many things which, as humans, we might take offense to, but as a judge, you just as you lay aside your ability for free speech. We're restrained from commenting as on this show. I can't talk about everything or give advice because of my position. Um, but just as we give up certain free speech, I believe we also must be restrained and moderate in terms of how we deal with those that we preside over, because it would be very easy to become very ruthless uh, about what we do, and totally within your discretion to do so based on what you have observed. But should you do it? And I think that the answer to the question is, even though you can, maybe you shouldn't.
Well, it's very, and I'm glad you went through that explanation, because I often tell people ask me questions all the time. Uh, the fact that I know you, right? The fact that I know you personally, and I know a couple of judges, but people ask me all kinds of questions. Um, and much of it has to do with, what I try to tell people is that when you go into the court, what you present to the court is, in many respects, you know, viewed as to what you think of the court. And I said that, how you present yourself to the court, physically present yourself to the court before you even open your mouth, um, has some weight in terms of how the court um, is going to have some judicial temperament with you. So, if you have to go to court, you don't go to court with your um, outside basketball attire on. Um, and I know that people come into court dressed all kinds of ways, but based on what you said, because I say to people that, and I say it in jest, but I try to paint a picture to them that the person who has the power and the discretion to turn your life inside out, other than God, is the person who wears that little black robe when you go into a courtroom. That person probably has the most influential power over your life. So when you go into that courtroom, you should really take that into consideration. But as you say, that just because judges have the power to do certain things, they have the authority and discretion to do certain things, restraint is important. However, I've been in courtrooms where there have been people who have just a couple of occasions that I've seen people, behave. Even one time in your courtroom that you still exercise, you know, um, restraint from even holding that person into contempt or even disciplining that person. There was this one particular time that I was in court, and I don't even remember the judge's name, that somebody was in on an eviction matter, and she was just being just overly obnoxious and rude to the court. And the court warned her several times. I mean, warned her more times than they deserved to be warned, because she was totally disrespectful to the court. And that judge went to the absolute end, right? To the absolute end, until the judge asked her to do something, and she just didn't want to do it and tried to storm out of the court, and then stormed out of the court. And at that point, the judge asked for the sheriffs to go and bring that person back into court. They brought her back into court, and the judge explained to her, look, your behavior is out of control. And I'm paraphrasing what he said, but he says that, I'm leaving this up to you. Now, I can hold you into contempt, or you can control yourself, and you can adhere to the court. And the judge was trying to help her because she was clearly in a defenseless position. But, and I'm really speaking to the point of how judges withhold their power that they have to do something. And again, I just tell people, look, you don't go into a courtroom, acting as though you have it all in control, because you don't. You don't. The person who has it all in control in that courtroom is the judge, regardless of what they do. But that is the person who holds the power in that courtroom, and you should respect it as so, because it'll work in your favor, not against you.
Yeah, and I often say to folks, you don't get a second chance to make a first impression. So just as you commented about, you should be careful in terms of how you present yourself, because if that's the first time that I'm observing you, that will impact my impression of you. And also, I'd like to comment that the court itself is entitled to a certain dignity. Uh, Put aside the personal aspect of it, it is the process that you should not offend. Um, I put my personal feelings, leave them in my chambers. I don't bring them into the courtroom because I think it would be too easy to be personally offended by some of the things that we see and hear in the courtroom. So I leave those in my chambers. But you must respect the dignity and the process of the court. That's really the line for me. And I have, as I've mentioned, I've never held either a self-represented litigant in contempt nor a lawyer, because I think that really indicates that they are controlling me. And if they're controlling me, then I don't need to sit on that bench.
Understood. Well, I think that I, for one, and it's certainly my opinion on the whole Donald Trump thing, I think that he's denigrated and disrespected the process of the court way beyond a person who of his position. And I think at some point, um, I would think that beyond this election, um, if he is to lose this election, which we're really hoping that process that we're saved of having to endure him for another 4 years as president. We're going to have to endure him, period. But as president, I certainly hope that we will not have to endure him. But I would think that if he is not successful at winning the election, that the courts are not going to be as patient with him as they are now post the election. Would you think that the courts are taking a much more sensitive role because of the election than they might look at these same tactics after the election?
I think that's certainly a factor. But again, it just depends on the environment that we will be in at the moment. He has seemed to encourage his supporters to support him by picketing the various court locations where he has appeared. Um, that's conduct that certainly does not respect the democratic process and the judicial process either. So I think these are factors that will have to be weighed and evaluated in the moment. But certainly, just as a decent person, I don't know how you pick on the judge's family. I mean, that's not just not good conduct. Just not, what's the phrase, good home training, if you will, where you're picking on someone's family who has nothing to do with the process. They're not involved in the decision making whatsoever. And there have been moments when he's come to the defense of his own family when they've been criticized with respect to how they've operated in the past. So it's no different than the rest of us.
Yeah, I guess in these last 6 or 7 years or 5 years or however long it's been that we've had to, even consider these things, no one would even think of even going, yeah, judges are criticized, but I don't think that we've ever seen judges be at the security risk that we've seen judges at this level in modern time. Yeah, the judges have been targeted and that sort of thing. But I think that
and,
uh,
and attacked and killed. In fact, judge was killed in the Daly Center where I sit a number of years ago,
mhm,
which really led the wave to the kind of judicial security that's in place in our courthouse and the federal courthouse down the street, and also around the country because of the public reaction to their situation and apparently believing that they're not treated fairly
right.
with respect to the cases that they're involved in.
All right, yeah. So, yeah, the process is very important, and it's and certainly needs to be regarded. And so, folks, when you go into a courtroom, or because at some point in time you're going to have to be before the court, just know that how you present yourself, the court sees that when you walk into the courtroom. So just remember that. All right, so let's get into well, speaking about eviction, before we get into we're going to talk a little bit about the Illinois State Judicial Board of Review and some questions related to that. But speaking about eviction, somebody raised a question to me just before we got on the air that they have an eviction situation, and the person was in a relationship. I don't know whether they're married, and the husband left. The husband left, and they said that the person was arguing with them about asking the landlord to provide them with information as to when the husband left, because they are behind several months in their rent. And I said, well, first of all, that's not a legal argument. It's not a legal argument. It's really none of your concern when the husband left or did not leave. They're both equally responsible for the rent. So that's, that has no bearing on you. Can people use those kinds of circumstances as mitigating circumstances to whether or not they owe their rent?
I think the simple answer to that is no.
Yeah,
There is some language in a statute that talks about domestic violence situation where that may be a mitigating factor. Um, but run of the mill was never run of the mill, but a situation where there is a marital breakup for whatever reason, that's not a mitigating factor in terms of the rent payment.
okay,
Normally, if both parties sign the lease, it's joint and several liability, responsibility for payment. So even if one leaves, the other is still liable fully for the rent. Now they may have a claim against the departing spouse for a fair share, of the rent payment, but it does not stop the landlord from seeking full payment from the party that remains, or whatever party they can find in order to pursue rent collection from.
All right. So, so the answer to that question is this: number one, no, there was no legal argument whatsoever to bring them relief, but they are responsible for the rent, but they could also, in a separate matter, go after the other party that is equally responsible to the rent to try and recover damages or half of whatever the judgment amount that they would be responsible for.
Yeah, to contribute to payment of the debt.
All right, fantastic. All right, so let's get into, we're going to talk a little bit about the State of Illinois Judicial Inquiry Board. Can you tell us what that is?
That's the equivalent of what is referred to as the Attorney Registration and Disciplinary Commission, which looks into ethical breaches by lawyers. The JIB looks into ethical breaches by judges, active judges, no matter what level, trial court or appellate court. If there's any issue relative to a member of the Illinois Supreme Court, it would be done as a impeachment proceedings. It's not done at the commission level.
And speaking of impeachment, what are the ways that judges could be removed from the bench, from a circuit court judge to an appellate court judge, even to a state Supreme Court judge?
Well, a state Supreme Court judge can be removed in an impeachment process, meaning charges are brought, a trial is conducted in the state legislature. So it's a situation similar to on the federal level where the House acts as prosecutor and the Senate acts as the jury, and renders whether or not they believe a violation has occurred, and if it has, what's the appropriate sanction. For trial court and appellate court, those complaints that relate to an ethical violation, alleged ethical violation, are investigated by what's referred to as the Judicial Inquiry Board. And that's a separate agency under state government that looks at conduct by judges in performing their judicial duties. They can also look at conduct, frankly, off the bench to see if it somehow affects the public perception of the judiciary system. So it's not just what you do on the bench, it's what you really do in your ordinary life that also could be subject to review. So the Judicial Inquiry Board is an investigative body, and they receive complaints, and sometimes they also initiate investigations on their own if they somehow come across information that suggests there is a possible ethical violation. And let me distinguish the difference between disagreeing with the ruling and an ethical violation. Those are not the same. If you disagree with how a case is concluded and ruled on, but does not involve any question of an ethical violation, then you appeal it. You appeal it to whatever the next level is. But if you believe there's been some ethical conduct involved that is a violation of the canons of ethics, then that is a matter that is considered by the Judicial Inquiry Board. Now, interestingly enough, every complaint of that nature does not necessarily involve letting the judge know that they're being investigated. They can undertake an investigation, and if they conclude there's no merit, without getting the judge involved in terms of answering or providing any information, they can do that. I am told that I don't know the volume of complaints that are registered against judges, but many of them are deemed meritless. And if so, and don't necessitate any investigation of sorts, then the judge is never even apprised of it because it doesn't rise to the level of any suggestion of an ethical violation. However, if there is an investigation that occurs, and the JIB, as it's commonly referred to, believes that there is in fact an ethical violation, um, then they act as a prosecutorial body, and they file a complaint in what's referred to as the Courts Commission. The Courts Commission essentially is a trial court for ethical violations by judicial members. So if the JIB files a complaint, essentially it is tried and prosecuted before the Illinois Courts Commission. Um, some of the members of that commission, I won't profess to know exactly as comprised, but it is both lay people and also active judges. And I
So
think
they
at
do.
least one member is a member of the Supreme Court, state Supreme Court.
Okay. Um, well, I could imagine that there must be all kinds of just loads of frivolous complaints lodged against judges, pretty much the same way that I'm sure that there are so many um, frivolous cases that or complaints lodged against police officers. I mean, from every little thing just because somebody didn't like the outcome that they wanted to somehow um, blame the judge or suggest that the judge conducted themselves in some way that was inappropriate. So I would imagine that they probably look at a lot of those. Now, you were just talking about the makeup of the inquiry board.
Yeah, I think it's 7 members, but don't hold me to that. And I think at least one member is a member of the Illinois Supreme Court. I'm not sure how they decide who that is, and then the others are comprised of.
I think we just there we go. I think we got you back. We don't have your volume. We're trying to get the judge's volume back. I think we don't have his volume back. Judge Murray, I don't think we have your volume. We can't hear you. I think your mute is on. Yeah, we can't hear you. Somehow we've lost the audio feed. Let's see if we can't get it back. Hold on one second. I'm going to take you out and then I'm going to bring you back in. Let's see. Just hang on just a second, folks. We are having some technical issue here where we've lost the judge's audio feed. We can see the video, but we can't hear you. Can you hear me? Judge Murray, can you hear me? All right, so we're going to wait. Try your audio now. We can't hear you. We've lost your audio. We've lost your audio. You want to try to go out and come back in, Judge? All right, try to come back in, and we'll see if we can't get your audio back in. Oh, let's see. Hang on one second. We're going to try to put you back in. I think we still lost you. Your audio. Somehow we can't get your audio back in. All right. All right. Okay. So the judge is going to try to come back in, and hopefully we can get him back in. But as we were talking about earlier, talking about eviction cases, and that if you have an eviction case, then it is pretty straightforward. It's pretty straightforward. If a landlord and a tenant, okay, let's see if we can't try it again.
Yeah, I'd
There
lost audio.
Okay. All right. We're back. We got you now. Okay.
right.
Fantastic. Okay. So you were talking about the makeup of the inquiry board.
Yeah, it's 7 members, and I think one member is a member of the Illinois Supreme Court. I think one member is a trial judge, and I think the rest may be civilian, or at least civilian members, lay members, uh, some of which may be lawyers, and then normally there's at least one member who is a lay person, meaning not from the legal community.
Okay.
But don't hold me to that. I'll track that down for next week.
Okay.
But I'm not sure about the exact composition of the courts commission.
Okay. All right. And the question here was, can I get a judge off my case if I filed a complaint against the judge?
Not automatically, but it might make sense if the judge is aware of the complaint, so that you eliminate the issue of whether or not that person may be biased against you in terms of the ruling. But it's not automatic that can occur. But if the presiding judge or chief judge becomes aware of the complaint, they certainly can cause the judge to be removed from it, just by virtue of their administrative authority. But it is not necessarily automatic.
And how does someone file a complaint against a judge with the inquiry board?
Well, they have a website that you can go to and initiate the complaint, or you can call in or mail it in.
Okay. And what's the usual time frame? Is there a usual time frame as to how a complaint is addressed or resolved in a matter?
There is not.
Mhm.
In fact, I was there is I'm aware of a current complaint against a judge, and it has been active now, I want to say, for somewhere between 9 and 10 months. Their process and the work they do is not public, so that unless a complaint is filed, you really don't know what they're doing behind the scenes in terms of their investigation. But I cannot give you a rule of thumb in terms of how long it might take for those proceedings to begin. And then plus, if the complaint is filed, then it's going to go before the courts commission, and that's a whole nother process. Please understand though that the JIB is an investigatory body. They do not have the authority to actually sanction um, a judge. It can only be done by the courts commission.
So that's a different different board than
Yes.
the inquiry board just basically processes the information and makes a determination and provides that to the commission.
No, it only goes to the commission if a formal complaint is filed. In other
Mhm.
words, a charge is filed that the JIB then prosecutes before the courts commission, or somehow is involved in moving it forward before the courts commission. If the JIB does not believe that any action is warranted, then it goes no further than that. But the JIB does not have authority to sanction or punish a judge.
And so, and if someone has a complaint against a judge, and they have a case, the question is, should they delay their appeal until the investigation of the judicial misconduct?
No, nope,
No.
no. There are timelines for that, and your complaint about a judge does not stay the timeline for pursuing your appeal.
And are all complaints confidential?
Yes, until such time as a complaint is filed. I assume they're talking about complaining to the JIB.
Yes.
Until such time as a formal complaint is filed, it's confidential. And as I mentioned a few moments ago, sometimes judges don't even know that there's a complaint filed because it's part of the investigation. The JIB concludes that there's no merit to it or no basis for it. Many times they do not even apprise the judge of the fact that there has been a complaint and they are undertaking an investigation.
And complaints that are filed with the JIB, are those complaints in writing only, or are there interviews as well as written complaints?
Yeah, they investigate. So there may be witness statements taken. There could be depositions taken. It's really litigation of sorts. But there's documentation that is developed in order to both investigate and ultimately charge against the judge if that is the conclusion that they believe is appropriate.
So, and the only time that investigation starts, or that the JIB does an investigation, is if they believe that the complaint that has been lodged is one of merit, or when do they do investigations? Obviously, they look at a complaint and they decide whether this complaint may have merit, so we may need to look into this further.
Well, that is an investigation and may be limited or quick based on what the facts are in that particular complaint. But if they believe there's some merit there, what has been alleged constitutes an ethical violation, they can conduct an investigation. But the charge is what goes to the courts commission, and that's where the prosecution of what ultimately is the complaint occurs. If they don't believe there's any merit to the accusations that have been raised, then it goes no further. And as I mentioned, sometimes the judge accused never even knows about it.
Okay, so so they'll do their investigation. They'll do their investigation of sorts with the person who lodges the complaint. Now, can complaints only be lodged by people who are participants in the particular case?
No, it could be an observer. It could be, again, as I mentioned, the conduct need not only be related to judicial activities. It can be conduct engaged in interacting with your neighbor, so to speak. So it's not limited to what you do in a courtroom or in connection with your judicial duties in a courthouse. It can also be, so to speak, off-site activities that you engage in while you are an active judge.
All right. I think I want to make sure I got all those questions as it relates to that. Oh, and how long does it take? I don't know if we asked and answered that question. How long does it usually take, or is there a time like it?
Yeah, you did mention that before. There is no norm that I could safely suggest in this regard. Because we don't really know um, um, sometimes whether or not, in fact, there are complaints lodged that are being investigated. We really don't know.
Mm-hmm.
I think I mentioned to you that I'm aware of a situation now where uh, the the activity related to the charge, at least the investigation, occurred um, uh, more than a year ago. The the investigation in the complaint was lodged maybe 2 or 3 months after that. And the investigation, as I understand it, has now been underway for somewhere between 9 and 10 months. And I don't really know where we don't know where it stands because um, we don't know where what they're going to do with it.
Mm-hmm.
And
Bless you.
in this instance, thank you. The only reason we know is because one of the complainants raised it publicly. But in most situations, you never really know whether or not anyone has raised a complaint against a judge.
When you say they raise it publicly, what do you mean they raise it publicly? How did they do that?
They um, they registered a complaint um, uh, to someone above the judge, um, either his presiding judge or the chief judge. And that complaint somehow became, the fact of the complaint somehow became public. Um, and I can't, at this moment, recall to you exactly uh, that process,
Mm-hmm.
but it was one that became a public issue. Uh, that there's no charge yet. What the JIB is doing with it has not led to a formal charge before the Courts Commission at this moment. Um, but uh, the complaint and the alleged facts are generally publicly known, and that is somewhat unusual.
Okay, we're talking for those of you who just joined us. We have a few minutes left, but we're talking with the supervising judge of the Cook County Circuit Court, Judge Leonard Murray, who is in over the housing division. If you have any questions for the judge, please post your question in the comment section, and then we will read them to the judge, and he will respond to your questions. Just remember that the judge cannot give legal advice, but can certainly answer questions related to a legal issue. Judge, you're the supervising judge of your division. Is that what your official title is, right? You're the supervising judge, and what does that mean?
I'm still trying to figure out the answer to that question. But so the housing section, and I often say that term is a misnomer because what we do in our section is we preside over all matters related to health and safety as it relates to real estate in the city of Chicago and unincorporated Cook County. There are parts of Cook County that are unincorporated. They're not a town, village, or municipality of any sort.
Mm-hmm.
So they're subject to county government control. Um, but anything from you need new sidewalks to broken windows, more serious matters. If there was a fire and the structure's been compromised, but any and everything that relates to building code violations. Sometimes it relates to activities that's occurred at the location for which there's not a permit for that activity or license to engage in that activity on site. So all those sorts of matters that pertain to the activity on real estate we cover. I had a case a couple years ago that involved a Gold Coast parking lot. There was a need to effectuate certain repairs in this parking garage that was down along North Michigan Avenue towards Oak Street, and I had to order every vehicle in that garage vacated until such time as the repairs were effectuated. So any and everything that relates to real estate in Chicago is subject to our court's jurisdiction. These cases are brought by the City of Chicago Corporation Counsel's Office, emanating from the building court. Uh, we also act as a reviewing body on cases that come from the city's administrative hearing section. So 400 West Superior, 95th and Jeffrey. I think there are 2 or 3 other sites where you can protest a city ticket of sorts related to an automobile, certain citations related to property. Your grass is too tall, or some other condition on the property that the city believes is not consistent with code. Uh, if you disagree with the outcome there, you have a right to seek court review. That process is called administrative review. You just have to make sure that once you receive the final order from the administrative hearing officer, that you file that case in the circuit court within 35 days of the entry of that order. If not, we don't have jurisdiction. There are very few exceptions to relax that filing rule. So that's important that you meet that deadline.
And Bob Fiorati asks, this is going to be our last question, ask, what is a day like for a supervising judge?
Hello, Bob. I have to make sure, well, we have 5 courtrooms in my division. So I have to make sure that we have coverage in every courtroom. We have 5 courtrooms with 6 judges, including myself. So I have tried to make sure that we have a fair distribution and allocation of the workload, and also to make sure that all the judges are sufficiently engaged in what we do in the division. So a couple years ago now, we had 1 vacancy, and the chief judge saw it in his infinite wisdom to send me 2 judges. And someone argued that, well, you could have not taken a court call and just sit in your chambers all day and be a supervisor. That's just not how I'm made up. So I have a court call. I preside over the condo call. That's all issues related to condominium property in the city. Also do the heat call. I also handle administrative review cases. I preside over the intake of those cases, including I have a call that I preside over for ruling and disposition. And I spread the rest of them around the other 5 judges in our division. I also preside over what's called the DIGS call, which is drug and gang house enforcement. And what else did I do? Oh, the county call. And that's the one that relates to real estate matters outside of Chicago in unincorporated Cook County. So that's what I do.
Now, in doing that, okay, and this is going to be the final question. So in doing all of that, so you get the caseload for all of those related type cases, and then you have to disseminate those to the judges within your under your supervision.
I do that as it relates to the administrative review matters. I handle all the cases on intake. I review what the issues are, and then assign them to one of the 5 courtrooms that we have for hearing. And I also sit in one of those 5 courtrooms for intake and then also for hearing. But as to the what I call the building code cases, we set up a system a number of years ago to assign those cases to a certain courtroom based on territory and subject matter. So we have two courtrooms that deal with the demolition call, and that's a call that is divided the city into two parts. So one half of it is in 1109, and the other half is in courtroom 1111. Monday through Thursday. And then we have conservation, which are cases where there are violations, but they're not serious enough to consider that the property should be demolished. And there's some other sort of specialty things that occur within our division that are assigned to certain rooms. So that's an administrative process that we devised a number of years ago, so that cases are handled efficiently. And also they're tied to the day of the week that the inspectors come to court. So certain inspectors deal with condominiums. Their cases are, the properties they're involved with are Monday morning. That's why my Monday morning call is maybe one of the most complex calls that we have in our division. Uh, and then the others are spread around in divisions on various days that we set up a number of years ago. So that's what a supervising judge does.
All right.
And then handle any other problems that come up along the way. In fact,
Yeah.
as you know, Mark, I have the 95 migrant bus cases that the city filed back in December. So that's a special court setting that I set up to handle those 95 cases.
Right, exactly. And what he's referring to is that all of these buses that are transporting migrants into the city of Chicago, lodged a lawsuit against, I think it's 38 plaintiffs, 95 cases. And that is defendants, I'm sorry, 30. There's 95 defendants.
Yes, no, 95 cases, but there are 38 different defendants.
38 different defendants, right. Very interesting case, and so he's presiding over that case. I'm actually following that case because I'm very interested in what the outcome of that is. All right, listen, there are more questions related to the case, to the court, and we're going to talk about that. And we also want to talk about the chief judge, judge's position on our show next week. So folks, again, any questions that you have, you can email me at markjwus@gmail.com. Any of your legal questions, you can send them to me all throughout the week, and then we compile them and prepare them so that the judge will be able to respond to them. You're listening to or watching the Legal Hour edition of the People Show every Saturday from 1 o'clock to 2. Judge Leonard Murray, who is the supervising judge down at the Cook County Circuit Court in the Daly Center. If you have property, you may end up before him one day, or if you have some red light camera tickets or speed camera tickets or weed tickets or any kind of administrative reviews, and you are contesting that, you will see him first before it goes any further. Judge Murray, thank you very much for joining us this week, and we'll look forward to seeing you next week.
Thank you again, Mark. Enjoyed it today.
All right, fantastic. Thank you so much. We'll see you next week. All right, folks, that's going to do it for me for this edition of the People Show. Look, don't forget to tune in Monday night at 7 o'clock. Monday night, 7 o'clock, we're going to be talking about the differences between Democratic administration and Republican administrations going back from 1933 up to 2020. The information is going to be it's going to be rather interesting. And so we're doing a deep dive into seeing how we have fared under the different administrations. There have been 7 Democratic presidents and 7 Republican presidents since from 1933 to 2020. And you're going to learn all about how we have fared under the different administrations. Coming up Monday night, 7 o'clock, intellectualradio.com, Facebook, YouTube, and Instagram, as well as X, formerly known as Twitter. Thank you all so much for joining us today, and we will see you on Monday night, 7 o'clock.